Joining us right now in studio is Tom Fitton, the president of Judicial Watch. Good to see you, Tom.
Hey, good to see you.
How was CPAC for you?
It was great. It was busy. A lot of fans, so it's hard to move around, but it was great.
Yes. People love that Tom Fitton. Everyone has a bad case of the Toms. But the reason for that is because you've been aggressively pursuing the government for years, and you've accrued a lot of respect, especially among conservatives, for doing that. And the latest iteration is that now a judge has ordered Hillary Clinton, of all people, to appear for a deposition as a part of this lawsuit. She will be forced to testify in this deposition about her email use. Tell us about what happened yesterday.
Well, he issued an order saying just that. And this is a case, believe it or not, about the Benghazi talking points. Remember those infamous talking points that were used to lie to everybody? We had sued for that back, I think, 2014 now. That lawsuit actually led to the disclosure of her email system. We forced them to admit they had these emails.
Oh, so your lawsuit was the predicate to everybody finding out that she had a private email server?
Oh, yeah, because we asked for the emails. We didn't get what we were expecting. We said, what's going on here? And they came back to us and they told the court essentially, well, we gave Judicial Watch everything other than these other documents we have to talk about. And then a month later, it leaks out they got the Clinton emails. And so Judge Lamberth, in this case, he's a bit upset. In late last 2018, he said, look, I want to know if Hillary Clinton was using this system to avoid FOIA, whether there are other emails to be found, whether they were messing with me in the sense they were trying to shut down this case before we disclosed it. Mm-hmm. And he also was interested to know, was there material about Benghazi in this email account that would give motive for them to hide it. Outrageously, the Justice Department and State Department opposed this every step of the way. Getting discovery, the judge granted us discovery. He took some witnesses. As the judge noted in his ruling yesterday, look, there's just more and more information that's coming out, including new Clinton emails that they don't have any explanation as to where they came. And we were in court in December of, just a few weeks ago, December of last year. Mm-hmm. And the Justice Department, State Department sent 6 lawyers to try to oppose our efforts to question Hillary Clinton.
The Trump State Department. The Trump Justice Department did.
And the president, he saw a tweet about this. He retweeted it. He said, this is a disgrace, and it is a disgrace. And this State Department, this Justice Department have been covering up for and protecting and defending and trying to excuse Hillary Clinton's email misconduct. But, of course, we've uncovered their own misconduct in the course of doing so. This is more than just about Hillary. It's about the State Department, Justice Department. We found the Obama White House was involved in the cover-up. So now Mrs. Clinton has to come in, testify about these documents, testify about the Benghazi attack documents. We get to try to figure out whether there were documents about Benghazi that we don't have. And all within 75 days. So we got some work to do, and there's some other interesting discovery, too, that we can talk about.
I'm kind of blown away personally by the fact that there are still emails being resurfaced or uncovered in this whole process. And I just want to know, and I think our listeners want to know, exactly are they coming from? Do you have any sense of how these new emails are coming to light?
The FBI supposedly is finding them somewhere and giving them to the State Department that processes them and turns them over to us. And the judge asked the same thing at that court hearing. And the Justice Department had no explanation, and they still haven't given us an explanation. We just got another batch last week. Well, it includes classified information, talking points for a call with Barack Obama, and a Benghazi-related email.
So what you're referring to is all official conversations. These are official communications.
We wouldn't be getting them if they weren't government documents.
Right. Not only are they government documents, but the conversations themselves are about government activities specifically, which makes them government documents. And Hillary had told us, her team had told us back in 2016 that the only emails that weren't being turned over to the government were personal in nature. In fact, I think yoga routines was one of the things that they referred to. They're like, no, we're not sending over everything. The personal stuff is personal. We're not going to send it over. Did, at any point, Hillary's team or Hillary herself place herself at legal risk for lying about the nature of the emails that they were actually passing to the government?
You would think, but this justice...
Because everybody else gets busted for lying to government officials. What about Hillary?
Well, Peter Strzok and James Comey were running the investigation. What do you think happened? The Justice Department under Obama had zero interest in prosecuting her over the mishandling of classified information. She took 60,000 records with her, or 60,000 emails, whatever the number is, deleted half of them, And we've been getting the material that the FBI was able to recover or find that she did delete, and it includes classified information, includes government information, as you talked about, and it's the sort of thing that many other people would have been prosecuted for.
When Hillary was first asked about this private server, she claimed that she set it up for convenience reasons. Do you expect that's still going to be her excuse? I mean, the judge suggests that perhaps she was doing this to avoid FOIAs like the ones filed on behalf of Judicial Watch. Is there going to be any change in what she testifies now that she has to do so under oath in person?
Well, that's been her written answers under oath. Obviously, she said that publicly. You know what's interesting? We just got an email from Peter Strzok the other day. And in that, he says, Hillary Clinton, at the end of her interview, apologized to the FBI for the time and expense in investigating it and said she did it out of convenience, but it turned out to be anything but. Mm-hmm. So you've got this...
No kidding.
Yeah.
You get this apology, admission/confession made at the end of the interview, and Strzok says we didn't put it into 302, which is the official FBI report. So now we have confirmation the FBI didn't put everything she said into the report. It's crazy town.
You don't need to hire like some, Top Gun consultant to tell you it's not more convenient to put a private server in your home and hire an outside company to do that. It's ridiculous. The excuse on its face.
And you can see it in the email traffic. It wasn't convenient. And we had testimony in one of our another case about this.
Right.
One of her top officials saying it was a pain. It was impacting her ability to do her job.
Okay, more in a second. Tom Fitton's here. We're going to talk about Hillary Clinton set to give a sworn deposition within the next 75 days. 6:44 on WMAL. All right, we're sitting with Judicial Watch President Tom Fitton, who has scored a big victory yesterday in that Judge Lamberth, the U.S. District Court judge, has ruled that Hillary Clinton does need to submit to a in-person deposition under oath to explain herself and her email practices. Tom, I love the questions that Lamberth directed at Clinton and said these are the ones she still needs to answer. I'm just going to quickly read them. How did she arrive at her belief that her private server emails would be preserved by normal State Department processes for email retention? Who told her that, if anyone, and when? Did she realize State was giving no records response to FOIA requests for her emails? If so, did she suspect that she had any obligation to disclose the existence of her private server to those at State handling the FOIA requests? And why did she think that using a private server to conduct State Department business was permissible under the law in the first place? Tom, as I'm reading this, I'm realizing Judge Lamberth is not giving her any quarter here. He's clearly almost as upset as you are about this stuff.
Well, and he's noted she's testified before, as I say, giving us written answers under oath, and she testified to the Benghazi Committee and such. But this wasn't covered, and to the degree she answered any questions related to this in writing, you don't really get much in the way of straightforward answers. The court highlighted the fact also that there are all these issues about what she remembered and not and such. And he said that one way to get around that, assuming that she can remember material, is to give her documents and say, do you remember this? And refresh her recollection and follow up. And that's why it's important to be able to to have questioning be taking place in person. So this is something that she opposed. And incredibly, as I say, the State Department and Justice Department opposed it. And the judge knocked the State Department, not the Obama State Department, but this State Department, this Justice Department, repeatedly in court. And most recently, yesterday, he said it was preposterous, their argument to shut it down. He said there are all these questions outstanding, and to tell me that we have everything we need to know is preposterous. And he said it's not acceptable that they're still dribbling out emails. He wants to know what's happening here.
And part of this case, too, is that he's allowing subpoenas against Google for uncovering further records in this case. I assume that would tell us perhaps if there are more emails floating around, and also the capacity for her private server to have been compromised by an outside actor like China.
Yeah, I haven't even thought about the second point, but the reason initially we've been granted the ability to send a subpoena to Google is because one of her email vendors allegedly sent all of her emails to an email address on Google. So the judge is like, look, let's see what's there. So you can subpoena Google. Maybe you can find the emails. I mean, this is a Freedom of Information Act request, so this is ultimately about getting the documents. And one of the areas of discovery is to find out where the emails might be that otherwise haven't been produced. Now, remember, she deleted 33,000. As best I can tell, the FBI has only been able to recover or find 5 of those 33,000. So there's 28,000 plus records out there that, where are they?
But if every single one of those emails was copied to a Google account, it's very possible Google does have control of those emails. So that'll be really interesting. Now, one of the stories that I always think of when we get into like Hillary's emails is the fact that she did have email conversations with President Obama.
Right.
Now, Obama had pretended that he didn't know about the server, but he was emailing with her on her private email address. That's for sure. What do we know about Obama's emails, and will we ever see them?
Well, we do know there are at least 19 email communications with Hillary Clinton, I think written by Barack Obama. Either way, they're going back and forth. And they're around the time of the Benghazi attack. It looks like it was many of them are in September and October of 2012. All of them are being withheld as communications privileges, presidential communications. So that's something the Trump administration can disclose if they want to.
Right.
Much of the classified information, it's harder to get out. But what the sort of material I'm talking about, it's all discretionary in the sense they can release it if they want to, but they choose not to.
And meanwhile, Hillary has to give this sworn deposition in the next 75 days. What is Judicial Watch doing to prepare for that?
Well, we got to find a date that everyone's comfortable with, and we'll depose her in person. We've got a group of attorneys whose hard work has resulted in this big victory for accountability.
Right.
And I don't know if Mrs. Clinton will appeal this. I doubt it. So we're just going to have to set a date and get ready.
Do you get to sit in on the deposition?
In theory, yes.
Are you going to do it?
We'll see.
What do you mean, we'll see?
I don't know.
You haven't thought about it?
I've sat in prior depositions of senior officials, so we'll see if we can do it again. But the important thing is getting her testimony, not who attends.
Well, you earned a front row seat, so I would think you would take it. Would you let us know when you do? When you make a decision?
Well, we'll announce the testimony when it happens,
okay.
And
all right.
I'll let you know if there's anything I can share about.
Mr. Gets information out is all of a sudden is like all shy. Thanks very much, Tom.
Well, you never know. It's a court process, and I don't want to presume anything.
Fair enough. 6:53 now on WMAL.